Hello there, thank you and welcome to another edition of the Evening Review. My name is Ogito Greg, and in studio with me this evening, Mr. Elias Shikongo, the President of the Namibian Employers Federation. Good evening, sir. How are you?
Good evening. Well by me, and thank you very much for the invite on behalf of the Federation I represent.
You are very welcome, sir. The Federation has recently expressed concern about ministerial involvement in labor disputes. Can you tell us what the concerns are?
Well, it is correct that I know your colleagues in the media reported on some remarks and some statements that the Federation make on the topic of the ministerial involvement. Yes, concerns they are, but if you would have had regard to the contents of these remarks and media statements, you would have picked up that the remarks relates more to not so much the intention of the minister, but the impact on industrial relations.
Yes.
Hence our comment on the issue.
Can you give us some examples that have raised these concerns?
The concerns are very important, not so much the examples in relation to companies that features in these instances of ministerial intervention. We of course have specific industries. Mining is one of them, manufacturing, and of course much prominent, and I think the onset of what you now term ministerial intervention, the mine in Tsumeb, Sino mine, I believe.
The smelter.
The smelter.
Yes.
Yeah, I think it was widely reported that it's a company that was in the midst of a restructuring process. In other words, following the due process as provided for in terms of the law. And we believe that the ministerial intervention, as reported on in the media, was one aimed at resolving the issue.
Yes.
The concern and the remarks we made in relation to that intervention and other intervention such as that one relates to the impact it can have on labor relations in particular, because there is legislative provision for that type of intervention. And the question arises, for instance, where is the next ministerial intervention? For instance, you could be the owner of a small and medium enterprise. If there is disputes at home, will it qualify for ministerial intervention? If you pick up a dispute with your domestic workers at home or even farm workers, will you qualify for ministerial intervention? So it's not so much the instance of intervention that is being addressed, but its ramification and consequences for labor relations in general.
You mentioned legislation. What are the legal bounds or limits that apply to a minister of labor in terms of how directly the minister can intervene in a labor dispute?
Oh yeah, Namibia is a constitutional state, which means that we are governed by the rule of law. Literally all aspects of life, be it civilian, be it commercial, be it in this instance labor relations, is statutorily provided for. In this instance, you have a minister of labor amongst others, as you say, intervening in instance of labor dispute. Nothing wrong with that. However, when it's done, it must be done with circumvention and with due respect to those statutory instruments that are placed there to provide exactly for that. As to statutory intervention, Parliament, our lawmakers, they deemed it necessary to specifically provide for institutions such as, for instance, the Labour Commissioner, Labour Inspectors, Labour Court. And there is a circumscribed procedure covering the entire life cycle of a labor dispute, from inception, going back to arbitration, mediation, adjudication, and eventually an outcome for the parties therein. So as you can see, scope for ministerial intervention in that mechanism of dispute resolution is very, very, very limited, because minister, by his constitutional mandate and appointment, once he's appointed by the president, operated at an entirely different level. Most importantly, at the level of policy. Policy, hopefully, which is informed policy, which impacts on the contents of legislation, policy that direct, for instance, what is the philosophy our labor legislation would follow.
Yes.
So if you have this instance of intervention by a public officer at that level in disputes of any nature, then you create a dangerous precedent. And when, and I think this must be underlined, when concerns are being expressed in this instance, it's not concerns necessarily only from employer perspective, because mind you, employees themselves, the public sector in general, private sector is heavily impacted on this, because on the one side, as you've pointed out, there is a statutorily provided for mechanism for resolving and dealing with labor disputes. You have a minister tasked with overseeing the industry as a whole, not only for employees, not only for public service, not only for employers, but for the entire tripartite system. So through social dialogue, and it's through this type of engagement that you get policies and legislation that regulate us all in terms of what is to be made. Now, with this particular topic which we are addressing, the question then arises on the one that I have already asked before. What is the criteria for ministerial intervention in an instance of labor disharmony? Is there a criterion for this, or does the minister get to pick him or herself? Secondly, when the minister does so, is there a temporary suspension of the mechanism provided for by law? The answer, I think, is self-evident. The mechanism provided for still remain, and nothing by way of constitutional mandate, ministerial mandate, extend as far as the minister becoming an adjudicator and becoming, if you want, a warrant executor through directives in terms of what is to be made or not. Of more important, we're talking about job creation, we're talking about investment in the country. You can imagine if, by way of advice to any investor who wants to come in the country, you want to lay out your labor regime in terms of how that relationship between an employer and employee is covered. And on the one side, you've got the law in precise terms, in very specific terms, indicating what is the route to be followed in order to achieve a certain outcome, regulating harmony between employer and employee if it's a labor dispute. And on the one side, he or she might have well have picked up that, wait a moment, there are instances in which ministers actually can intervene towards resolving a dispute, even in the middle of a retrenchment exercise, even in the middle of or at the onset of a dispute not yet registered. How, as an investor, or let's not go to investor, how, as a local employer, must I advise? At which juncture does the minister get involved? And when do you qualify for ministerial interventions? The lawyers will ask, is this mero meto? In other words, is this an intervention coming from the minister himself, or does he get to be invited? Can he refuse when he's invited to intervene in the dispute? And does it follow that once he intervenes and a directive is given through his intervention, that it can be refused? So what then happens? What happens is then the absence of predictability, consistency in applying your legislation, and most importantly, there's just no certainty on what is the legal regime applicable, because the minister is otherwise doing what is not, let's say, empowered to do. Once again, as I've stated from the beginning, it's not so much the intention he has, because we must accept that the intention the minister has in doing all of this is to bring about harmony, to resolve dispute. But then the danger is the consequences and impact of that intervention where it's not codified, where it's not regulated, where there's basically a total absence of guidelines on when, how it happens, it brings about, unfortunately, chaos. Which is not only detrimental to employers, but to employers themselves. Because there might well be an instance where a union or an employee or a small and medium enterprise feels that they are not happy with the outcome of, say, judicial proceedings. Do they, in that instance, ask for the ministerial intervention? And if so, can the minister say no? In other words, predictability, consistency is the concern that is being addressed, not so much the intention to bring about providing a solution to a dispute.
As they say, the road to hell is paved with good intentions. But I wanted to ask, bearing in mind the current situation and what has been done by our minister, what has been the impact in terms of how employers and the industry in general see labor inspectors and the Office of the Labor Commissioner? Has there been loss of respect, perhaps, or loss of consideration for the powers of those statutory positions?
It's a loaded question, and I must, I think, be careful what I answer, because I cannot answer for the Labor Commissioner. Publicly and by law, we know what her duties and functions are. They are described in full detail as to her involvement, or him, if that's the case. In this case, it's her involvement in the labor dispute industry. Same goes for labor inspector. Same goes for arbitrators who underwent trading and are statutorily empowered to adjudicate on dispute. So the answer possibly lies in legislation, because take into account that the minister is the overseer and is the reporting and responsible authority in terms of the industry. And it becomes more complicated when you know that through our policies and governing ways, the accounting officer of every minister is an executive director.
Mr. Shikongo, let us pause there before we go into the further complications, because we have to take a quick break for this commercial break, but we'll get more into this very interesting conversation in a minute, so please stay with us on the Evening Review. Welcome back to the Evening Review. My name is Ogito Craig, and in studio with me this evening, Mr. Elias Shikongo. He is the president of the Namibian Employers Federation. Mr. Shikongo, you were elaborating on how complex the impact of the current situation is, but let's take a different tack. Let me ask you, why is predictability in terms of Namibia's labor regime so important for the country?
It's rooted in what is called the precedent system. In other words, if a particular set of facts in a dispute are adjudicated upon in a properly regulated adjudicatory forum, result in a certain outcome, you want to be able to rely on that for future references.
I see.
Because that's how you determine your jurisprudence. That's how you determine your law. That's how you regulate, by example, in respect of what has come out of the court. Now, the issue of intervention provides a very good example, because when you have a political office bearer with all good intention attempts to resolve a dispute, the question that arises for those who must advise for those who must employ and for the employee, him or herself. The question that arises is, what are the rules applicable in arriving at a certain outcome in a dispute?
Yes.
Is it political considerations? Is it labor considerations? Is it legal considerations? Or what considerations are there? Is it the party that speaks the loudest? Is it the party that carries the minister's favor? Or even in some instances where objectivity is maintained by the political office bearer, there is nothing in our law that provides a documentary outcome of that process, the adjudication itself, and the outcome. So there is no reference point. Because that brings us back to the question you just asked. When you have, for instance, a labor commissioner who has defined functions, or mediator who has defined roles and obligations when it comes to dispute resolution, what is it that they do when another person who is not specifically authorized for that, political office bearer or any other person for that matter, what is it that they do? And remember now, when it comes to any of the parties being not happy, unsatisfied with the outcome of the intervention, do they treat that intervention as a judicial process, administrative process, or do they just treat it as an informal engagement to achieve a certain result? So uncertainty means exactly the type of questions that I'm asking. Is the same avenues in respect of review, appeal also available to parties that are not happy? Or does this still go back to the forums where it was supposed to be in the first instance? So there is a lot to be said about a very well motivated initiative at promoting industrial harmony in the country. But remember what we said in the beginning, the outcome might not have the same result. So that both the stakeholders in this process, the employer, the employee, and public sector for that matter, become victims in the process. And we've now concentrated on private sector. What happened when, say, nurses who are employed by government, or teachers, or for that matter, police officers, although they are not unionized, but what happened if they feel that the minister has achieved success in resolving one or another dispute? Do employees in the Ministry of Mines and Energy, Health, Foreign Services also get a right to insist on ministerial intervention to solve that? Or is this a remedy or avenue only reserved for, say, for instance, those in the private sector? Your question is one of predictability. It's clear that when procedures, rules, statutes are being followed, designed and crafted to bring about a mechanism of resolve for one particular instance of a dispute, for instance, predictability and consistency is present. You can advise based on that, and you can plan based on that, and you know in some instances to settle. You know in some instances that this is a dispute worth pursuing. But when you deal with a political office bearer, the same considerations do not apply because of the reasons that I've just alluded to. In other words, in as much as there is an understanding that sometimes an additional year will be required to, I must call it, to give a semblance of intervention and assistance, this must be to the very, very minimum. And if it can be avoided, better yet, for all of us, including employees and employers.
Bearing in mind our history in Namibia, from colonialism and apartheid and eventually to independence, before which there was terrible exploitation of workers, and juxtaposed to the need, urgent need, that we have for more employment. What would the Employers Federation want to see the minister do instead of what has been done recently with this ministry? How would the NEF want an ideal Labour minister to act?
I believe peaceful, cooperative industrial relations must count amongst the high priorities for our Minister of Industrial Relations, Labour and so on. And it goes without saying that this is also an aspect that is of importance to employees and employers on the other side.
Yes.
Because if you have good industrial relations in the country, normally it goes hand to hand with a reasonable cost of living. It goes hand to hand with a living wage. But in our current set of circumstances, we as employers realize and are first to recognize that there is high cost of living,
Yes.
which on the other side also impact on employment creation. So what is it that employers themselves can do practically? And what is it that we expect from a minister?
Yes.
First of all, he's a facilitator. He's a facilitator. A minister, a political office bearer, operates at the level of policy. And how does that policy come about? Or even the sister of policy, legislation. How does good policy or legislation come about? Through a consultative process. A consultative process engaging both the social partners in our relationship, in this case, the employees, the employers, and government itself,
I see.
in an environment of trust, in an environment of mutual respect. Out of that, we get directives, policies, legislations that incorporates all our view. That's at the level of regulations.
Yes.
But more practically, when it comes to work creation, number one, the creation of an enabled working environment for employees,
Yes.
employers in this instance.
Yeah.
Because if you have an enabling legislation, not legislation, but an enabling environment,
Yeah.
work creation strive. And when there is a positive environment for workers, we create jobs.
Excellent.
Jobs
Shikongo?
means
Yeah.
employment.
Yes.
And maybe lastly and most importantly, an aspect that is stressed by all factors, there must be skill transfer and upskill of workers
Yes.
in whatever it is that they do. Because without skilled workers, to which employers must also contribute, our future, unfortunately, in terms of good industrial relations, is not guaranteed.
Thank you very much. And thank you very much for joining us on the Evening Review. Tomorrow evening we'll be back with a different topic, but for now, good night.
Good night.